everyone, welcome back. So we were getting into parliamentary staffers and ministerial advisors. So the book touches on this somewhat in chapter 5, but ministerial advisors and staffers who work in Parliament House are technically not part of the executive. They're actually employed under the Members of Parliament Staff Act 1984 Commonwealth. And would you believe it, sort of slipped between the three constitutional branches of government. Now that has some issues to play because they wield phenomenal power. As you can see, there's Peter Credlin with previous Prime Minister Tony Abbott, and an academic Yi Fu Ng, formerly of the Graduate School of Business and Law, currently working out at Monash Law School, gave a speech to Parliament House, and there's a link there to it, about the role of ministerial advisors in the modern Australian political system, and noted, do you remember we've got these codes of conduct, so if you work for the civil service you can't have a political position, but the advisor is in a partisan political role, so they are pro political view and tend to work for one camp rather than the others. They often talk to the press, public servants. There's a convention that they can ring up ministers and other DepSecs and senior members of the executive and make directions, and it's as if they're carrying the weight of the advisor or staffer, the person that they're advising. So they yield phenomenal power. They can address, as I say, the press, public servants and interest groups. They can be extremely influential. So, for example, the Prime Minister's Chief of Staff is known as one of the most powerful roles in Australian politics, even sits in on cabinet meetings. Isn't that phenomenal? Yet not bound by the rules of the public service or other members of Parliament and political conventions. As you can imagine, they work very long hours and invariably develop very close relationships with ministers. And I think the key point to note is that they're unelected and they're quite murky in how they're appointed. They've often come up through the rank and file of political parties, and they go along with the minister and along with the MP as they get given a portfolio or a ministry. They just come along. So they may not have any expertise or qualifications in the field, but just have to learn on the job. There's no position description, there's no advertisement. By convention, they're unaccountable to Parliament, so ministers can claim parliamentary privilege, but also can claim the privilege over their staffers and advisors. So these select committees can't call them to give evidence because they sort of hide under the political convention of parliamentary privilege. And in this speech, it does suggest that this is quite a new convention. It's just sort of crept in recently, but obviously governments and members and politicians quite like the privilege shroud falling over their staffers who know the inside information on all their business. So this convention is historically shaky. It suits ministers to claim it and avoid accountability. So have a think about that and whether you think that's a good thing. So we talked about the executive, and we talked about Parliament and the importance of parliamentary committees in houses of review, houses of review holding the Parliament and the executive accountable. And we noted in jurisdictions where there's only one house, that's even more important that the parliamentary committees hold the executive accountable. However, there are several bodies within the executive trying to perform complementary roles. We've got the Australian Human Rights Commission, which investigates and resolves complaints about breaches of international and domestic human rights law. Noting we don't have a Human Rights Act in Australia, a federal one, a Commonwealth one. There's a fair chunk of Chapter 5 on the power of ombudsman. Little toothless in that they're mainly mediation, and they can investigate maladministration. They try and resolve grievances. They can write recommendations to the minister around any executive action or processes or procedures in their portfolio that's suboptimal, but quite limited on their powers. And the Chapter 5 contrasts the power of the Ombudsman in Sweden, which is phenomenal over the judiciary and the executive. We also have tribunals where we can review certain decisions. And the big one, the Commonwealth one, is the Administrative Appeals Tribunals. We've got a slide on that coming up. And there's some discussion around the integrity of those bodies due to the appointment of tribunal members. We have a privacy commissioner, and again we'll talk to the power of the executive to reduce budgets, to reduce that to just one person, the office, with a few very limited their capacity by funding reductions. And then finally, there are some anti-corruption bodies. We've got the Australian Commissioner for Law Enforcement Integrity. We have to be very careful when giving power to the police and to agencies who can detain and investigate and seriously infringe your liberties. Then we want to make sure those powers aren't open to external corruption or forces and or are used lawfully. We've got ICAC, the Independent Crime Commission Against Crimes, New South Wales, and there is to date no Commonwealth equivalent, and there is a bill before Parliament, draft bill, it's never got to Parliament, with reduced powers, and there's no sort of federal push for an anti-corruption, independent commission against corruption. Sorry, that's what it stands for. The ICAC. Now there's an IBAC, a Victorian equivalent, but again, no federal equivalent, which is concerning and suspicious that federal politicians don't want a federal watch body to ensure that members are not acting unlawfully or corrupt, or having members of family and friends and business associates benefit from the exercise of executive power. We saw a case only last week, didn't we, where a member in New South Wales has been dismissed from the government whilst pending an investigation due to his sister having a company that benefited from a planning decision in his electorate that he'd been pushing forth. So the big question is, we've got these agencies, they're trying to hold the executive to account, and we know it's important to hold the people exercising power to account. We don't want them to go beyond the power, ultra vires, but can such agencies be truly independent? And that's the question. And the problems here are illuminated. So John Daly was, until quite relatively recently, head of the respected think tank, the Grattan Institute, and he did a huge final report in 2021 and suggested some executive institutions such as the Reserve Bank of Australia and the Productivity Commission as truly independent. However, did point to some executive accountability bodies that were unfortunately not make that level of independence objectively. So the problem seems to be, or a problem, there's Grant there, who's the Auditor General, put a link there to some budget cuts, and the problem is the executive is in charge of the funding for all of these independent overview and watchdog bodies. So if you strip the ombudsman, for example, in Victoria of a budget, then of course you reduce the effectiveness of that body's ability to exercise oversight over the executive. So there's some media reports there worth a look, because you need to appreciate they exist, but you need to appreciate the limitations on their ability to do what they were set up to do. Because if the very people controlling the purse is who they are charged to investigate and govern and look after, then you do have to worry about the true independence of those bodies. We move on to royal commissions. This is another way of holding the executive to account, and usually happens when there's been a huge whistleblowing or media outcry and a public outcry over essentially a policy failing. Something's gone catastrophically wrong, and in response, the government looks like they're doing something by launching a royal commission. Let's investigate. So it's a way of calling for expert review and investigation into a specific bespoke area, usually, as I say, triggered by media scrutiny and public outcry in a certain area of public policy failure. So they are technically, their power comes from the Governor General on advice from Cabinet by means of a letters patent, which is a fancy letter, under the Royal Commissions Act 1902. Now, Chapter 5 goes into the power. They have broad coercive powers, and in the photo there is the Aged Care Royal Commissioner Linnell Briggs delivering the report to the Governor General, and there's a little report there. We've recently had the Robodebt Royal Commission report handed down back to the Governor General. So they are very useful and powerful as long as they the recommendations they end up or recommending get actually implemented. And as we'll see with the Royal Commission into Aboriginal Deaths in Custody, that's not always the case. So there is various ombudsmen around the country have been warning of a systemic dysfunction in, for example, aged care, disability services, prisons, immigration centres for years. But oftentimes it's when, as I said, there's media outcry that then generates public outcry to a related story, and it becomes a hot political issue. Government needs to seem to be responding, so they often will turn to a royal commission as evidence of taking the matter seriously and responding to the public outcry and the electoral you and I to try and pacify our outrage at the failings. So there's been a lot. I've got a list there. We've got the Royal Commission into Institutional Responses to Child Sexual Abuse, mainly focusing on the churches, failures and regulation and oversight. Royal Commission to Home Insulation Program under the Rudd government during the GFC, where 4 workers tragically died due to a lack of training and being in lofts in the hot Australian summer trying to install insulation. So that was rushed and rolled out. The Royal Commission into Trade Union Governance and Corruption was, some say, quite a political Royal Commission by the Prime Minister at the time, Tony Abbott, just got elected, and then wanted to have a look into trade union corruption. You can join the dots politically. Royal Commission into Child Protection Youth Detention up in the NT due to tragic deaths in custody and horrific practices of isolation and solitary confinement of youth. There was a Royal Commission to misconduct in the banking, super and financial services industry, shocking lending practices, giving people loans where there was no real ability to pay them back, etc. Loose banking standards, aged care, quality safety. We just looked at that one. There's currently 2 commissions here: Royal Commission into Violence, Abuse, Neglect and Exploitation of People with a Disability, and I put a link there. It's the final ceremonial sitting on the 15th of September this year. It's about to conclude. And the Royal Commission to Defence and Veteran Suicide, and again the public submissions are just closing. I'll put a link there to their website too. So there's been a lot of them, and there's some recent ones. Now, some research out of Monash found that 50 years of them can make a difference, and oftentimes their recommendations are implemented by the government and legislation then follows, and they do lift an area. Our last week's case study into third-party labour hire contractors, suppliers of workers out in regional and remote Australia, but also, as we saw, it was actually implemented across all industries. So you can have some royal commissions that or inquiries have immediate effect, with great legislation passed and a new statutory authority created and a whole regulatory machine invented and in place to govern that space. Whereas contrast that view with Stephen Bartos, who was a former senior public servant, said royal commissions are expensive, time-consuming, drawn out and often inconclusive. For most policy issues, a poor substitute for properly resourcing the public service to do policy well. Well, if government is so opposed to the idea of lawyers' picnic, why royal commissions which generate huge windfalls for law firms? I mean, the banking Royal Commission was a lawyer's picnic. But anyway, you know, do you want the public service to be better funded to do their own research into their own policy failings, or is it better to have a relatively independent body conduct that? I mean, the commissioners are often retired judges and at arm's length from the current government. And then there's the idea as well, well, hang on, why not take the Ombudsman's often recommendations and you know, responses to complaints, why not respond to those before these things become disasters and scandals? You know, if we know there's lots of complaints in the aged care sector, why do we have to wait for a Four Corners report blowing the lid on disastrous conditions before these problems are addressed via Royal Commission recommendations? Now, there's the AAT textbook on Chapter 543 looks at the Administrative Appeals Tribunal, which has jurisdiction to look at decisions on the merits, so not around the law attached to it, although you can complain that the law's not been properly exercised. That's really the case for judges and the courts, but administrative appeals look at the actual conduct of the decision which you believe. So it might be lawful to say no and decline you a license, but you feel that the way that the process has been run is unfair, so you can appeal on the merits of the decision to the AAT. We've got one in VCAT, Victorian Civil Appeals Tribunal in Melbourne here, that are court-like bodies. They're generally less formal, they're cheaper, you don't need legal representation, although oftentimes, certainly the government department is very well represented by lawyers, but us as members of the public can complain about a decision not to get Austudy or not to get a visa or not to get an appeal overturned. So unlike the Commonwealth Courts, they can review government decision on the merits, and they can determine whether the decision maker made the correct or preferable decision. She versus Migration Agents Registration Authority is authority for that, where an agent got their license revoked improperly, and then the AAT reversed it. Now, note related bodies which enforce the regulatory schemes are not tribunals, such as the ABC or the HRC and the Ombudsman. They don't have the powers of tribunals. They can't reverse the decision, and they're different. So just briefly, the admin decision, you're not happy with it, often there's an internal complaints procedure. You can raise your objection. There's usually within 60, 90 days or whatever it may be. You might be able to have a look at an intermediate tribunal, or you just go off to the AAT. Now, if you don't like the decision at the AAT, you've got one more chance to appeal on the merits, and that's up to the federal court on a single judge sitting. And then the courts are rather about the matter of law, that there's been an incorrect use of the law, not of the facts. So where do tribunals get their powers? Well, interestingly, under Section 25 of the AAT Act, an enactment may provide that applications may be made to the tribunal if, for a review of decisions made in the exercise powers conferred by that enactment, or by another enactment having effect, which means that the AAT has no inherent jurisdiction, rather that under a subsequent piece of legislation, say the Social Securities Act, it would have a section saying decisions under this act are appealable to the AAT. That's the power of the AAT to then investigate, but they can't just review decisions like superior courts unless it's physically approved to do so in the act you're complaining around the application of. In the 2019 election, the government made a rush of appointments to boards, advisory councils and tribunals, and appointed 57 new AAT members out of about 250 with Liberal Party connections. And a similar round of appointments was made just before the 2022 election. So we need independence of these tribunals. Otherwise, if they're the very bodies that exercise scrutiny over the executive, we must make sure that they're independent and they're not stacked politically to carry on the will. So the ALP has promised to introduce a robust, accountable, transparent system, because currently there's no position description, they're not advertised, it's just taps on the shoulder. Have a look at how appointments are made. There's a speech by Sir Gerard Brennan there, and even Justice Callanan report recommended in a report that most non-lawyers be barred from the AAT. Currently, you don't even need to be a lawyer to sit. A lot of them are. Some are judges sitting not in their capacity as a judge, but as a member of the executive in the AAT, reviewing decisions of the executive. But it's all a bit murky waters, and they're very well paid, huge salaries, and appointed, I think, for 6 years. Anyway, needs to be independent and transparent. Transparency as a form of accountability. We do need transparency on the government's the executive's action. All these departments. Now, if you go on most of these departments' websites, have got an about. They do have annual reports detailing expenditure, etc. We've got media scrutiny on them. However, that's limited to access, isn't it? And modern privacy laws can outlaw secret filming, for example. We've got freedom of information requests, but as noted before, that freedom of information, or the privacy commissioner, was down to one person there for a while, so they've just been reducing the volume of staff and budgets to reduce the amount of FOI requests and volume of data they can release. There is whistleblower and leaks protection, but in some some government departments now it's unlawful. It's a criminal offence to speak to the media about what goes on in your department. I know in migration, for example, you go to jail if you talk to the press about internal goings on. We do have the Public Interest Disclosure Act, which is meant to protect whistleblowers, but there's a real issue around true independence of freedom of information and transparency around what goes on in some areas of the executive. Well, I'd be interested in our chat next week in the tutorials what you think are the most effective accountability mechanisms to hold the executive to account in a transparent nature, and why you think that might be so. So yeah, the FOI law overseen by one man working from home, it's not ideal, is it? We've got one person acting as the privacy commissioner. Investigation revealed other systemic flaws. Have a look at some of these links here. We've got a report from the Guardian and the Sydney Morning Herald. So these freedom of information teams are shrinking. Here's a document in the top right. It's been so redacted, it's meaningless, isn't it? What's the point? That's not transparent, is it? Obviously, with the reduced resources to deliver, they can just deny requests and say, oh, sorry, it's too onerous. We haven't got the resources to give you that document. It can take months and months to get them. Statutory deadlines under the Freedom of Information Act are often ignored, and who's going to enforce them anyway? And anything with interesting information are often redacted. So how transparent is it really, our freedom of information? Why is it important to hold the executive accountable for its actions? Why don't we just give the executive free rein and just let them have power over the citizens, and we just get rid of all of those executive review bodies? Well, remember Lord Hailsham's warning around human nature tending towards abuse of power, and we end up with elective dictatorships where pretty much it's a dictatorship between elections if we don't hold our executive to account. Or the similar warning from Justice Dixon in the Australian Communist Party case around, often in observation, it's members of the executive wielding power who then go on to break the constitutional arrangements to take the power. Great speech by Professor Gillian Triggs, who was the former Human Rights Commission president for many years, around overreach of executive and ministerial discretion, a threat to Australian democracy. I'd be interested in your views on that. And an academic from Luke Kemp warns of a stomp reflex that governments tend to have in times of emergency. For example, the pandemic, where people's civil liberties were totally removed, and earlier the 9/11 terrorist attack on the Twin Towers. The raft of legislation that was introduced after that around the world on the basis of terrorism was astonishing, and civil liberties shrunk as governments tended to, as Luke says, exercise their stomp reflex of power, their use of power, often an overreach. And if we don't hold the executive to account and make sure that they're not overreaching power, then again, our civil liberties will be deleted. And of course, academics have the benefit of some time and reflective, time to reflect back on history and warn. Whilst we're all in the emergency of COVID and everyone was panicking, it's important to reflect on the use of powers and whether that was appropriate. Okay, well done. Thanks for listening. Next week, we're going to look at the courts and the judiciary, the third arm of government, and separation of powers, Chapter 3 in the Constitution, the courts. Thanks, everybody.